Hi, my name is Bill Miller. I'm an estate and elder law attorney in Alabama. I have offices in Anniston and Birmingham, and we have clients in all areas in between. One of the biggest mistakes I see people make in estate planning is that they do not have a power of attorney. So I'm going to talk to you today about the three things you need to think about regarding a power of attorney and why it's important. So I think the first thing is to explain what a power of attorney is. So a power of attorney is just a legal document that you sign that gives someone else the legal authority to make financial decisions for you if you're not able to do so yourself because you are incapacitated or incompetent. Maybe you have Alzheimer's or some other form of dementia and you're no longer able to make financial decisions for yourself. A power of attorney gives someone the authority to make those decisions. Cash your checks, pay your bills, sell property if necessary, access your retirement accounts. Anything that you can do financially, then a power of attorney should be authorized to do. Number two, it's also important to realize that you need to have a very thorough power of attorney. Just the average power of attorney that you print off the internet probably doesn't have all the powers in there that someone might need. And a power of attorney has to be very specific. If all those things, all the powers you want to give someone are not listed in there, then it may very well be that you have this false sense of security that you have this document, but it really doesn't do what you need it to do. And if you have dementia, you can't sign a new one. And then number three, what happens if you don't have a power of attorney? And I see cases all the time, families in my office all the time, where mom or dad didn't sign a power of attorney, and now the children have to act on their behalf to cash their checks or pay bills and things like that, and they don't have the authority to do it. Being the executor of the will doesn't give you authority to do it. So if you have to act, if someone has to act on your behalf and you don't sign a power of attorney in advance, then they're going to have to get a conservatorship over your money. Conservatorship is a court proceeding where the probate court then supervises how your money is spent, where your money goes, and things like that. A conservatorship is a very lengthy process, and your relative is going to have to take the time to go to court on a regular basis, do an accounting of all the money that they spend, and things like that. So a conservatorship is much more burdensome on your loved one than just giving them a power of attorney, which does the same thing. And the other thing about it is when you do a power of attorney is you get to decide who makes these decisions rather than having the court do them. The court doesn't mind doing it, but they don't know you. They have several other cases, and they don't know what your wishes are. So by having a power of attorney in place, then you get to pick a trusted loved one to make these decisions for you rather than relying on a court. But again, a conservatorship will work. I've done several of them. It's just a lot more time consuming, a lot more expensive, and a lot more burdensome on your family members. If you have any questions about this, I encourage you to visit our website at www.millerestateandelderlaw.com, or if I can be of help to you, please give me a call at 256-241-6794. I look forward to meeting you.